Good afternoon, everybody, and welcome to the July edition of the question and answer session with Jason Killeen. I'm your host, Jason Killeen, and I just want to welcome today, we have a guest moderator. So if you could go ahead and unmute yourself and introduce yourself.
Thank you, Jason. Good afternoon, everyone. Thank you for joining us. The first question is from Rick J. Do you still have funds available for the DCR fee waiver to get to the CEQA clearance for the DCC annual license?
So Shalana is our guest moderator today. And yes, we still have local jurisdiction assistance grant funding available to provide fee waivers for the environmental review for the local annual application process for licensees that have a temporary approval from DCR as well as a provisional license from the state.
Thank you, Jason. The next question is from Chasem B. What is every inspection that is needed in chronological order to open my business?
There's two inspections that are associated with the Department of Cannabis Regulation. An initial inspection is required to gain temporary approval, and a final inspection is required to get your operating permit after an annual license is issued. Other agencies in the state also have their own inspections that are required for their own permitting processes, such as the Department of Public Health, the Department of Building and Safety, the Fire Department, the Department of Cannabis Control at the state level, and any of the other agencies that you would have to require or acquire a permit or license from in order to lawfully operate. But the two that are DCR specific are the initial inspection and the final inspection.
Thank you, Jason. The next question is from Sunshine P. In regards to delivery methods, what is the benefit of restricting delivery operators from utilizing a manner of delivery other than cars or trucks? Do you expect for those restrictions to be lifted in the future?
So we rely upon the state to designate what the authorized delivery methods are. So until the state changes the delivery methodology, we're just going to be kind of a partner in adhering to what they've standardized. Because of the need to ensure that folks provide identifications and sign for the deliveries, it's more akin to delivery of alcohol, where there has to be somebody there to collect the signature, and we don't have drones that are taking people around the city to make these deliveries at this time.
Thank you. The next question is also from Sunshine P. If a delivery vehicle breaks down or if a new vehicle needs to be added to the fleet immediately for any reason, what will the turnaround time be for registering a new vehicle with the DCR?
So you should just submit the appropriate paperwork as soon as you identify that a new vehicle is being added to your fleet and needs to be recognized as a specific delivery vehicle for your business.
Thank you. Michael O. asks, can retailers operate in a specific plan zone if that zone was added after 2007 and is not listed or mentioned in LAMC Article 5?
No. Only the specific plan areas and the zoning that is specific to that area are allowed for commercial cannabis purposes. At this time, any new specific plan zones that were added after 2017 that were not included in the original Article 5 are not listed and not included.
Thank you, Jason. IVN asks, I have a provisional license with the Department of Cannabis Control. What do I do next?
So you should be working towards annual licensure with the city and then also annual licensure with the Department of Cannabis Control. They have additional requirements in order to renew your provisional license, and all licensees are going to have to obtain an annual license in the near future. So you should be working towards annual licensure.
Thank you, Jason. IVN asks, should I pay the application fee if I am not a social equity applicant?
The answer would be yes for pre-application review fees. Or the annual license application fee, if you already have a provisional license, the annual license application fee would be waived utilizing the local jurisdiction assistance grant award. So
Thank
it
you.
really depends on, we haven't assessed any of the fees on the annual applications, but if folks are submitting new annual applications, the fees may be assessed on submission, and then we review it to determine whether or not somebody qualifies for a waiver.
Thank you, Jason. I'm sorry to interrupt you before. The next is from Katie P. For annual licensing requirements, do temporary approval applicants upload Form 4014, a premise diagram, and landlord approval lease to the annual record in the portal?
So for applicants that already have temporary approval that had their annual license application record created in May, you can use the existing landlord attestation, proof of site control, premises diagram, attestations, and the indemnification agreement to the extent that those documents are still valid. Otherwise, we will be publishing new forms later this month, and those forms can be utilized in lieu of any pre-existing forms that you have.
Great. Thank you, Jason. The next is also from Katie P. Do temporary approval applicants need to email an analyst when the upload is complete? How will we know that no further action is required?
So when you upload documents to your record, an email gets sent to the assigned analyst at the end of the day. So basically, there's a batch job that gets run that tells the analyst which records have new activity, so that, of course, they could follow up the next business day. So there's no need to email your analyst separately. But if they did send you an email specifically asking you to upload a document and you're responding to that, that's perfectly fine. And it may give them the opportunity to work on it the same day.
Thank you, Jason. The next is from Norma C. How is it determined how many licenses are approved per neighborhood?
So the soft cap until undue concentration is reached is based on one license per 10,000 residents in a community plan area. The council has already pre-approved an additional 100 businesses from phase 3 retail round 1. And then some of the businesses that were allowed to participate in phase 3 retail round 1 after 2020 are exempt from the calculation of undue concentration. But the general rule is one license per 10,000 residents within a community plan area.
Thank you, Jason. Norma C. also asks, do all cannabis business licenses have to go through public and neighborhood council's review?
The technical answer is no. The retail storefront license type will go through a public hearing, which is associated with the Cannabis Regulation Commission. So once a retail storefront application is deemed complete and we issue the notice of complete application, the Department of Cannabis Regulation will conduct a community meeting to get stakeholder feedback on that specific application. will summarize the feedback we received and we'll transmit it to the Cannabis Regulation Commission with the recommendation to issue an annual license. And then the Cannabis Regulation Commission will hold the public hearing at the time that they're considering DCR's report. Neighborhood councils are not part of this process. Businesses, retail storefront businesses are required to reach out to a neighborhood council to offer to meet the council, make a presentation at a neighborhood council meeting, but it is not a requirement for DCR's process for approval. And the neighborhood council is not required to schedule that prospective applicant at any of their meetings.
Thank you. Brandon B, Narbet A, and Mark R all ask, will there be another retail license lottery? If so, when? And how many licenses do you anticipate giving out?
There will be another lottery. I don't know when. And the number of application slots that will be, we'll select social equity individual applicants to fill will be based on the number of licenses that are available at that point in time. So it'll be somewhere probably less than 250. And as DCR issues more licenses, the number of folks that can be selected to submit applications, of course, will go down.
Okay, great. Thank you, Jason. Brandon B also asked, if I want to sell cannabis flower under my own brand, does that require a manufacturing license or a distribution license, or is it both?
If you possess the cultivation license and you're doing your own packaging and labeling, at a minimum, you would need a non-volatile manufacturing type P license to do the packaging and labeling at the local level. And if you're going to be, distributing your flower that is packaged to retail storefronts, you would need a distribution license. If you're basically leasing or allowing another company to use your brand and label products, that would be something that would be addressed through whatever your contractual relationship with those other licensees is.
Thank you, Jason. Rick H asks, how long do I have to find a new location if the owner of the property I'm leasing tells me that I have to vacate?
As part of the June 2nd amendments, loss of site control was added as a reason to abandon a record. And through the abandonment refiling process, applicants would have up to 3 years to refile their pre-application record. And then the pre-application review record and the refiling rules are articulated in the municipal code. If you're refiling within the same community plan area, you would not be subject to a finding of undue concentration, even if after you were abandoned and before you refile, that community plan area reaches undue concentration. And then if you're looking to relocate to a business premises address outside of your original community plan area, generally, you would only be able to submit a pre-application review record in a community plan area that has not reached undue concentration.
Okay, thank you, Jason. Levon E asks, if a retail location was ticketed more than 3 years ago because it was an illegal dispensary shop, but the case has been closed for over 2.5 years, would I be able to process that location for a legal dispensary, or has that address been red flagged and is no good?
That's really going to depend. We're working on trying to get a comprehensive list of locations that we can publish to the DCR licensing map, identifying business premises addresses that have been deemed that maybe scorched earth or may not be feasible for commercial cannabis activity for one reason or another. I would recommend sending an email to the CPRA account if you have a specific address, and I could respond to let you know if that address is on our existing list. If it was ticketed, but the city attorney's office did not prosecute, there was no utility shut off, there wasn't any type of padlocking, then the location may still be eligible. But if there was a conviction associated with the location, there was padlocking, a utility disconnection, that would be grounds for, well, it would make the parcel ineligible for licensure based on the LAMC.
Thank you, Jason. Samuel M. asks, does DCR provide referrals for investors that want to invest in my dispensary business?
No, we do not.
Thank you. Eugenia M. asks, are there any educational resources available for new applicants?
There's a bunch of materials, information procedures, bulletins, and other things on the DCR website that everybody has access to. And if you're a verified social equity individual applicant, you would also have login credentials for the learning management system that is maintained by the social equity team.
Thank you, Jason. Will S. and Ali E. ask, is there financial assistance available for approved applicants, and how can I obtain those funds to help with my cannabis business?
At this time, there is no direct financial assistance available for applicants. The social equity team is always looking for grant opportunities which would allow for them to provide additional direct financial assistance, but we don't have any active grants at this time. And then for certain existing applicants and licensees, we may have fee waivers available for different application processes.
Great, thank you, Jason. Jeff C. and Bobby V. ask, what effort is DCR taking to take a more active role in the enforcement of illegal shops?
So under the code, DCR does not have authority to take any type of enforcement action against an unlicensed commercial cannabis business. DCR does provide verification information to the police department, Department of Water Power, Department of Building and Safety as parts of their own investigation to verify whether or not a license has been issued at a location. Otherwise, we have no role in the enforcement efforts.
Thank you, Jason. Page B asks, does an increase from a small to a medium-sized existing cultivation activity require going through the PCN process?
The change in license type from small to medium would not require you to go through the PCN process, but at a minimum, you would have to submit an updated business premises diagram for review and approval to basically account for the additional area where cultivation activities could occur. And depending on what type of business premises modifications are being made, it may require an additional land use review just to ensure that it's properly distanced from schools.
Great, thank you, Jason. Adelina A. asks, how do you start with LADBS to get an inspection, and how long does that process take? Is it the same amount of time for LAFD?
So the pipeline to get into other agencies' permitting processes starts with the Department of Building and Safety. It's going and reaching out to them and going to the public counter so that they can look at the parcel, they can look at the permits that have been issued and what uses are allowed at that parcel is the best way to get started. And really, they would be the ones determining whether or not you would have to be routed to another department. So if you have to update your certificate of occupancy, or if you're engaged in cultivation or manufacturing activities that are going to require an LAFD permit, you'll have to start with LADBS. And then once that they've identified that you're in their process working towards compliance, you would get referred to LAFD. If you try to start with LAFD, you may be able to start the process, but they'll still refer you to LADBS to get their clearance before you move forward in the LAFD process. Depending on what types of permits and stuff you need is really going to drive what time it takes to actually get those inspections. But those permitting processes don't directly impact your ability to navigate through the DCR annual license application process. But it will be, you'll have to show evidence that you are in compliance with TBS and fire prior to being able to schedule your final inspection to get your operating permit.
Thanks, Jason. Arthur S. asks, I was granted a storefront license in the lottery. Can I open a second and third store? And is the application process is the application process open for me to be able to have 2 more stores?
So if you were selected through the lottery, that gives you the opportunity to submit an application for a retail storefront license. One license at the location that had completed the pre-application review process. The lottery selection does not allow you to submit a second or a third application, and we are not currently accepting applications for the retail storefront license from new applicants. So the application process is not open to submit applications for 2 more stores.
Thank you, Jason. Archer S. had a follow-up question. I have a license with DCC and provisional with DCR. I'm in the process of LADBS, but is it okay to open the storefront now, or should I wait to pass all those inspections with LADBS and LAFD and then open the store?
So if you passed your initial inspection with DCR to get your temporary approval, the question would just be whether or not fire department identified any fire life safety issues with your location. If not, and you're still in compliance with fire, then you could temporarily operate while you work towards your annual license and meeting the permitting requirements required for the annual license. You just need to make sure that you're in compliance with building code and fire code while you operate.
Thank you, Jason. The next question is from Ali R. When will the annual profile be updated for us to submit our CEQA?
So we began migrating records from the temporary approval process into the annual application process in early May. And in order to be migrated in early May, a business had to have temporary approval as well as have a current legal business entity record. Earlier this month, well, in June, we started to establish legal business entity records for applicants that had not previously created them, and for licensees who had not previously created them. And now we're in the process of migrating folks that weren't migrated over in May into the annual application process, and that will be done before the end of this month. So in order to provide the Form 4013, you'll have to have the annual application record in order to upload it. And if you already have an annual application record that's set to further information needed, waiting for payment, you would be able to go in and upload the document immediately.
Thank you, Jason. Crystal R. asks, please confirm that the recent ordinance changes now allow Phase 3 applicants who were previously deemed ineligible due to a sensitive use to move forward. Also, Does that apply to PCN applicants who applied and were moved forward but found ineligible due to a sensitive use as well?
So there were 12 phase 3 retail round 1 applicants that were part of the first 100 or the additional 100 that council authorized that were deemed ineligible due to their proposed business premises proximity to a sensitive use. So only the 12 folks that haven't yet had the opportunity to refile have that opportunity to refile. And we sent an email communication out to those social equity individual applicants. As it relates to the PCN process, PCN is not affected by that change. However, DCR will be opening up the PCN process by mid-August for 2 weeks to allow folks to submit a new PCN application for council consideration.
Thank you, Jason. P. Guevara asks, why is permanent supportive housing considered a sensitive use?
It was identified as a sensitive use type back in 2017 prior to DCR being created, and it remains a sensitive use under the Los Angeles Municipal Code.
Thank you, Jason. Paula B. asks, what are the soonest upcoming filing deadlines impacting current applicants with temporary approval that need to transition to the annual license?
I don't know how to best answer this question because a number of the filing deadlines are associated with the state. So the state at this point has phased out processing of provisional license applications. So if an applicant has not received a provisional license from the state, that stopped on June 30th. For folks that have provisional licenses that will be up for renewal, those applicants will each have their own expiration date for their provisional license, and you'll have to provide evidence of compliance with the California Environmental Quality Act to the state in order to renew an existing provisional license. For everybody else, you'll have to work towards annual licensure, and basically every application the state has now is going to be assumed to be an annual license application. DCR is doing the same thing where we're phasing out the temporary approval application process, and we're moving everybody into the annual license application process. Within our annual license application workflow, there is the ability to gain temporary approval if you can demonstrate that you have an existing state provisional license or state annual license. So there's still a way to get temporary approval through the local annual application process, even if you didn't submit a temporary approval application record. And then basically the processing timelines that are articulated in the code are in effect. So we are holding applicants responsible for getting information and getting to a complete application record within the specified period of time. And then if folks are being non-responsive or they're not getting the documents necessary to get to a complete application, it could result in abandonment. And then any record that is deemed abandoned will need to be filed as an annual application as of July 31st.
Thank you, Jason. Robin W. has 2 questions. The first is, are investors that are also equity partners able to get returns on loans they provided to the business and also receive 50% of revenues or profits until the loan is paid back?
And those terms would be allowed provided they were negotiated. So if a social equity individual applicant loaned money to the business and there's an agreement about the repayment of that loan and any interest that would be due on that loan, that's considered to be an operating expense. Separately, there's the requirement for the social equity individual applicant to get their requisite share of revenues and profits. And the distribution of revenues and profits is generally done after accounting for all operating cost. So if the loan was considered an operating cost and then profits are derived and then you get a percentage of profits, you would be able to get repaid on the loan as well as your percentage of the profits. But again, these are all private business transactions. And you would have had to have articulated that in any contractual agreements you have between yourself, your partners, and the business.
Thank you, Jason. The next question is it against DCR policy and procedure and or the spirit of social equity for an investor to receive more profit share than the equity they have? For example, if the investor has 25% equity, can they also get 40% profit share?
The social equity individual applicant should be receiving an equity share percent of the distribution of profits equivalent to their equity in the business. Again, the semantics of your contractual agreements kind of is important, because just like the prior answer, if the other partner loaned the business money and the loan is being repaid and it's paid out as an operating expense before profits and revenue are calculated, that wouldn't be considered a portion of their profit share. That's an operating cost you're repaying the loan. But if you've derived the profits and the social equity individual applicant is not getting the requisite share based on their equity percentage, then that could violate 10420. But we would need more information.
Thank you, Jason. Hovannes H. asked, the state deadline to submit a CEQA from the city is in September. How much longer are the CEQA reviews being processed?
So the CEQA review is an ongoing process. So for our annual license process, that's when we do the CEQA review. For businesses that are already in our pipeline, specifically the folks that have provisional licenses expiring in July, we've already provided the state with our draft recommendation for the environmental analysis. At the local level, we'll produce a notice of exemption or other corresponding environmental document for the complete application, specifically the complete annual license application, and it'll be part of that package. The environmental document can't be adopted by the city until we've made a recommendation to issue the annual license. And then the decision maker will theoretically adopt the environmental analysis with the recommendation to issue an annual license. So we are moving forward with the environmental documents. We're prioritizing folks that need those environmental documents to renew their provisional license with the state. And it's an ongoing process. So the requirement to do that review doesn't stop in September. As we get new pre-application records that transition into the annual licensure process, we'll have to develop the environmental reports for those documents in order to get through our annual process and get people through the state's annual process.
Thanks, Jason. Hovannes H also asks, are there additional documents or items needed after the CEQA for the state license? Can you go over the CEQA process and timelines? And do we have to refile the 4013 CEQA document we filed several months ago?
At the local level, the Form 4013 is the starting point for the environmental review. If you've already completed the 4013 and you uploaded it to your renewal record or your temporary approval record, and you have an annual license record, you can go ahead and just upload that same document to the annual license record, because it's part of the documents that are required in order to get to a complete application. If there haven't been any changes or to your activities, to the premises diagram or anything else, the form that you completed months ago can be uploaded.
Thank you, Jason.
Well, I was just...
My apologies, go ahead.
Oh, no. I was just trying to think about the other parts of the question. I mean, effectively, for a lot of what we've looked at so far, we believe that the project qualifies for a notice of exemption. And therefore, we don't need to move that project into the initial study, which would then look at other environmental factors and would become more in depth. If you do qualify for a notice of, if DCR is recommending a notice of exemption for your project, the 4013 would be the only document that we would need from you in order to produce the environmental report. If we review the 4013 and we believe you do not qualify for a categorical exemption, then we would start an initial study to get more information about your project so we could look to determine whether or not there are any impacts, and if so, how those impacts could be mitigated. But we haven't run across that situation yet. We have done a few different CEQA webinars, and I anticipate doing another one in the next couple of months. So just to get to some of the other questions, I would just invite you to look at the website to get some of that information and then register for a future CEQA webinar when it's available.
Great, thank you, Jason. The next question is from Jose R. When is the PCN process opening, and are there any new community plan areas open as well? How long will the PCN process be open if I am unable to find a compliant property?
The PCN process should open the second week of August. We're planning for it to open on Tuesday, August 8th. Provided there's no policy changes to have us push it back. We are intentionally having it open on August 8th because we will be updating the DCR licensing map with the new sensitive uses, because the next quarterly pool will happen on August 1st. Council's currently on recess, and of course, all of these PCN requests have to go to council for approval. So we don't want to transmit anything while council can't consider it so that you get the full 90 days. But effectively, on August 8th, we would open it up. Folks would be able to submit the pre-application review records for the retail storefront activity. If we determine that the proposed location is in a community plan area subject to a finding of undue concentration, you would have the opportunity to submit your PCN request and pay the fee for council consideration. The window to start your PCN record will be a 2-week period from August 8th through August 21st. And that's, the window is open for 2 weeks to ensure that we're able to consider all of the requests that are transmitted, and then folks will have the opportunities to pay the fees, and DCR can do the analysis. And then we can ensure that all of the PCN requests get transmitted to the city council within that CPA at the same time. So the city council has the full menu of PCN requests within a council area. And then, of course, the pre-app review, the review of the PCN request, the transmission to council could take 60 to 90 days. And then the council has 90 days to make the PCN finding. So in total, from start to finish, it takes about 6 months, or it has a maximum time frame of 6 months. And then we would look to open it again early next year, and then probably open it for a 2-week period twice a year on a go-forward basis. At this time, I can't speak to which community plan areas are unduly concentrated, but the last week of July, we plan to be doing a webinar to talk about the PCN process and what the steps are going to be and how people can file their PCN request. And at that time, we'll let folks know which community plan areas are subject to that finding of undue concentration, because it's based on the number of licenses we issue in the community plan area. So hopefully that helps. Stay tuned. We will be doing a webinar in a couple of weeks, just specifically on PCN.
Wonderful. Thank you, Jason. The next question is from N. Jackson. Are you going to bring back the social equity opportunity for applicants to apply for cannabis delivery licenses? And if so, when?
Folks that are currently verified as a social equity individual applicant can start the pre-application review process for the non-storefront delivery license type. If you haven't been verified, we will be looking to open another social equity individual applicant filing period. And, we're working with the city council to determine when that would happen.
Thank you, Jason. And Jackson also asks, are the licensing fees going to increase when you open the application process to everyone in 2025?
I don't know. We'll be transmitting a fee study later this year, which will incorporate all of the new position authorities and the record types that have been created since the last fee study. But I don't know what's going to happen to the fees in 2025 or later.
Thank you, Jason. The next question is from Ali E. Are Canadians allowed to apply for a license?
Natural persons, like Canadian human beings, can apply for a license and be an owner of a license. Canadian firms, like corporations, cannot be the direct owner of a license or the applicant of license or licensee, but they could have an ownership stake in the business as long as they're not considered a capital O owner.
Thank you, Jason. The next question from Mikia G is similar to a question we recently had. It's on the PCN process. Do you have an anticipated date for the PCN yet? And can you provide an update on the PCN application process and filing requirements?
We anticipate opening the public convenience or necessity process on Tuesday, August 8th. We will be doing a webinar later this month to talk about the PCN application process and the filing requirements, so stay tuned.
Thank you, Jason. Mark R asks, are there any new activities being made or worked on that would not require a property? For example, an event or consumption license that could be used at different locations or fairgrounds?
Not at this time. We are working with the mayor's office on the on-site consumption license type as well as the special event license type, but those have not been approved, nor have we made any recommendations to the city council about how and where those activities could occur. If somebody did get a special event organizer license, when they go to have a special event, they would have to apply for a special event permit from the state to identify the property where the event would occur, as well as go through the special event permitting requirements of the city. But at this time, all of the activity types do require a proposed business premises address and would have to go through the pre-application review process.
Thank you, Jason. Alexis L asks, how long until we will be able to submit a mod?
It should be open later this week. It will be open for folks that have the annual license application record later this week. And then, of course, if you have the legal business entity record, you would also be able to submit modifications against that record. But we're no longer allowing folks to modify the temporary approval application documents.
Thank you, Jason. Alexis L also asks, when will the final CPA map be finalized?
Hopefully, we're talking about a data table. We're in the process of putting together a dynamic data table that will get populated at least on a monthly basis, that will post on the website to let folks know how much license capacity there that exists within the CPA and how many pre-applications have been submitted, how many applications are pending in that CPA. And that should be up later this month. The goal is to have it uploaded to the website by August 1st, so that when we publish the updates to the DCR licensing map, that information will also be there.
Great, thank you, Jason. Alexis L also asks, how many annual licenses have been issued at this point?
0.
Thank you. R asks, how do we safeguard our license from being used by other people without your knowledge?
That doesn't give me enough information to provide an answer, but if you believe that your license is being used by someone else, that's against the law, and you can reach out to our compliance and enforcement section, and they can look into it, and if there is unlicensed commercial cannabis activity going on, a complaint can be submitted to the LAPD and other city agencies for follow-up.
Thank you, Jason. The next question is from Anahi. When will the new 5005 forms be available? When you produce, my apologies. When you produce the new forms, will we have to refile the documents again?
So the annual license application packet will be available this month. The forms that people have currently used for the temporary approval application process, to the extent that they haven't changed, can be uploaded to their annual license application record, and we can utilize them for the annual license application process. The 5000 series form is really intended for businesses coming into the application process for the first time, and it's going to streamline some of the forms that you'd previously submitted. So we're looking at consolidating the landowner attestation into a single document that would be submitted as part of the pre-app. We're looking at consolidating the different attestations into a singular document that can be populated, signed, and submitted. And then, based on the number of owners and stuff like that, that would require signatures. But by and large, the forms aren't changing a lot. What's most commonly changing on the forms is just with the revisions to the Los Angeles Municipal Code, some of the citations for the sections needed to be updated, but the core content is by and large the same.
Thank you, Jason. The next question is from Dana C, looking for confirmation about a few different form numbers. For the annual application, can you confirm whether we are supposed to refile the forms 4016, 4007, 4020, 4005, 4013, the premise diagram, and the lease?
If the existing documents are still valid, then you can just upload those to your annual application record. So you wouldn't have to refill them out and refile them. You can just, resubmit what you've already filed.
Great, thank you, Jason. Dana C also asks, how do we set a hearing with the neighborhood council?
When the annual license application record is deemed complete and the applicant or licensee receives their notice of complete application, we'll include the local neighborhood council on that note. We'll include which local neighborhood council is the business premises is located in, and the email contact for that neighborhood council, so that the applicant could reach out to the neighborhood council, let them know that their application was deemed complete, and offer to come and visit the neighborhood council to do a presentation or answer any questions. It's really up to the neighborhood council. Once the applicant or licensee's responsibility is to reach out and make the offer to the neighborhood council, and then it's up to the neighborhood council about whether or not they want to have the business present or they have any questions for the business.
Thank you, Jason. The next question is from Anahi. If the Elber information is different from the original submission, do we still need to submit modification requests, or will an invoice automatically be generated for changes to the record?
If you're creating an Elber at this point and you're submitting information that's different than the original application, you will have to go through the modification request process. And that should reopen by Friday for existing Elber records and ANN records. If you created your Elber during the renewal window and you uploaded information that was different than the original submission, as the analysts are going through the ANN records that we created and we're identifying discrepancies, they may invoice you for the changes that need to be made.
Thank you, Jason. We have less than 5 minutes left until 1 o'clock. However, we have about 10 more questions. So we will try to push through, but just let me know when you're ready to wrap up.
Well, I'll make time to get through the remaining 10 questions.
Great. Thank you so much, Jason. The next is from Jose. Can I apply for a temporary license without having a location?
No, you can submit a pre-app. Any of the records that you are creating for the purposes of getting a commercial cannabis license is going to have to be associated with the proposed business premises address. When you create your pre-application record, you don't have to have site control of the location, but you do have to propose a location so that we can look at the zoning and the distancing associated with that particular property.
Thank you, Jason. Dana C asks, can a phase 2 cultivation license be sold to a non-equity, non-phase 2 qualified buyer?
A phase 2 tier 3 cultivation license could be transferred to another tier 3 entity, provided that that entity meets the requirements to be a tier 3 applicant under the code.
Great, thank you, Jason. The next is from Anahi. Does the homeless population count towards the 1 per 10,000 residents in a community plan for undue concentration?
So the population counts are based on the American Community Survey. which is done annually. So homeless residents, to the extent that they're part of the count, and we do the big annual homeless count, that's to take into account changes in population and where people are located. The counts do include homeless individuals to the extent that they were present at the location when the count occurred.
Thank you,
So the
Jason.
simple answer is yes. Sorry.
Just a follow-up to that. How often is the data collected?
So the ACS, which is the American Community Survey, they do a data analysis once a year. And in July or August of the following year, they present their results to the Department of City Planning, at which point they'll provide us the population analysis for each of the community plan areas. And then we'll make the corresponding adjustments for, the license types that would be subject to undue concentration.
Thank you, Jason. MS asks, for an ownership mod, which TA forms are required in addition to the relevant mod forms?
So ownership modifications would get submitted against the legal business entity record. Generally, if you're removing an owner, we're going to need the ownership removal form, and we're going to need the 4004 form for the ownership structure, the 4003 form for the list of owners and primary personnel, the 4008 form for ownership and financial interest holders, a current org chart, and any changes to the authorized agent if applicable. But that modification would be submitted against the legal business entity record. And then once it's approved, those changes would get pushed down to all of the application and licensing records associated with that legal business entity.
Thank you, Jason. Christian asks, for the first 100 P3, phase 3 retail round 1 that were exempt from the undue concentration count, do they eventually count towards the community plan area once they receive temporary approval, or will they always be exempt?
Based on the municipal code, they're exempt from the calculation of undue concentration. So when we do our analysis of, how many licenses have been issued in a community plan area, we don't even consider the first 100. So unless or until the law gets amended, they're exempt from the count.
Thank you. Rafi S. asks, how can we confirm if a location has had a utility disconnect?
At this point, we're trying to get information from the Department of Water and Power so that we can push that information to the DCR licensing map. And hopefully, whatever information we've received will be part of the August 1st update. One of the purposes of the landowner attestation is the landowner should know whether or not there was a utility disconnection or other enforcement action at the location. And they're kind of attesting that something didn't happen. So once we get this information from the enforcement agencies and we're able to make it publicly available, applicants will be able to go to the DCR licensing map to see if there was an enforcement action such as a utility disconnect at a given location.
Thank you, Jason. 3 more questions. MS asks, for non-retailers, will their annual application need to go through an appeals process?
Hopefully not. For non-retailers, the annual license application goes to the director once it's deemed complete and we've completed the environmental review. DCR has the authority to deny an application based on the code anywhere in the process. So anything that's being referred to Michelle as director is going to be a recommendation to issue the annual license. And, assuming that she concurs with the staff report and the environmental findings, there wouldn't be a reason for the applicant to appeal. If she denies the issuance of an annual license, then the applicant would be afforded an appeal.
Thanks, Jason. Anahi asks, is the PCN process that's opening in August only for retail, or will it be for cultivation as well?
At this time, it would only be for retail. The city council adopted a resolution articulating the public convenience or necessity findings that could be made to support allowing DCR to process applications. At this time, all of the potential reasons are really tied to retail storefront activities. Part of those policy conversations that need to happen are, what types of findings the city council could make to support a PCN finding for the cultivation license type.
Thank you, Jason. Our final question is from Levon E. When is the next time or date that LADCR licensing map will be updated?
We'll be pulling new sensitive use data on August 1st, and it could take up to a week to get the data cleaned up so that we can push it to the DCR licensing map. But we have every intention of making sure that the licensing map is updated on or before Tuesday, August 8th, so that folks who are looking to participate in the retail storefront PCN process have the most up-to-date information, and they know what sensitive use data will be utilized when we review their pre-application review records. So I know that was the last question. I would like to thank everybody for tuning in today. Our next virtual lunch Q&A will be on Wednesday, August 9th at noon. So I look forward to talking to folks again next month, and stay tuned for that PCN webinar, which will be, we'll be sending out information probably by the end of next week, and we're going to have that before the end of the month. So thank you, everybody. Goodbye.